Welcome to our webinar on what was going to be all about the job support scheme until it was scrapped by the Chancellor a couple of weeks ago, so which is now on everything furlough. My name's Charlotte Geesin. I'm Head of Employment Law and Business Immigration at Haworths. Qualified solicitor, been advising employers on all things employment law related for the past 10 years or so, and over the last 10 months or so have been speaking predominantly about furlough, joined by Sarah, who can introduce herself, I'm sure.
Yeah, I'm Sarah Edwards. I am a senior employment law solicitor at Haworths. Been here about 4 years nearly, and I've been a qualified solicitor for about 9 years and done about 10 years of employment law advice, both for employees and employers, which is a nice mix. So yeah, we're here really to answer whatever questions you've got about furlough scheme, extended furlough schemes, etc. Because obviously we've had quite a lot of updates recently, so we'll hopefully be able to cover everything for you. We did have a few sort of initial questions come through prior to going live today. So Charlotte and I will cover those off for you first of all, and obviously anything else that comes up, let us know. Charlotte, I think we're right in saying if anyone's got any questions, you'll see a Q&A box at the bottom of your screen.
Yeah, that's right. So if you sort of wiggle your mouse over your screen along the bottom, there'll be a Q&A tab, sort of 2 speech bubbles. If you do have a question for us, and we hope that you do, just type it into that box. I think there's an option to be anonymous if you don't want us to know who you are, and we'll see those as they pop through, and yeah, we'll answer as many as we possibly can. If you can't access the Q&A, then by all means feel free to use the chat function instead, because we can see that, but the Q&A one will be much better if that's possible. So yeah, as Sarah said, we've had a couple of questions in advance, so thank you to the authors of those, and yeah, might as well launch straight in. So first one was Mathsy. So Sarah's going to take that one because I barely have a maths GCSE.
Yeah, I always get the joy of the questions that involve numbers. So I'll start with the first question we've had through. Now the question was, furlough calculations for those that have had changes to contractual terms or pay since returning back to work on flexible furlough. So there's a couple of points I suppose to make on this. There actually isn't any specific guidance out there on how to deal with any changes to contracts that have occurred during the last few months, really, and the impact that has on furlough. But there is guidance on generally how you should approach this sort of question. So when calculating what somebody should be paid when on furlough, it really depends on 2 things. One, whether it's a new period of furlough for someone under the extended scheme after the 1st of November, or whether it's for someone who has previously been furloughed under the furlough or flexible furlough schemes between March and the end of October, because you calculate differently depending on which version you're using. So if it's someone who's had changes to contractual terms since coming back on flexible furlough, that would suggest that they have previously been furloughed prior to the 1st of November. So to calculate what they should be paid, you actually use the same figures that you used for any previous period of furlough. So for someone who was on your payroll before the 19th of March 2020, well, it depends whether they're on fixed pay or variable pay, first of all. So if they've just got a fixed salary, it doesn't really change, then your relevant pay amount is going to be whatever they received in the last pay period before the 19th of March 2020. And that's even if we're obviously way down the line, there might have been changes, but there's nothing to suggest that you need to calculate differently. It just says that if they've previously been furloughed under the scheme before the 31st of October and were on your payroll before the 19th of March 2020, then you, for fixed employees with fixed pay, use the amount they were paid in the period before the 19th of March. For those on variable pay, so where during each pay period they get paid a different amount, what you use is the either the amount of money that they were paid in the pay period, in the same pay period in the previous tax year. So let's take April 2020. If they were employed by you in the previous tax year, you would use the amount for April 2019. So the pay period in the previous tax year. If they weren't employed by you during that time, then you do an average of what they earned with you in the tax year 2019-20. So there's a couple of options, and you take the highest of whichever of those applies, and that will be the amount you use. Obviously, whilst it's not technically part of this question, if for anyone that's going on to furlough for the first time since after the 1st of November, you use the amount that for fixed employees, it's the last pay period before the 30th of October. But for variable pay, you take the average amount of pay that they've earned with you between the 6th of April 2020 and the day before they're put on furlough. Or if they've not been employed with you since the 6th of April, then the date they started with you and the day before furlough, and you take an average. And that's the only guidance we've got on payment, really. They don't cover any specifics on contract changes and what have you.
Thanks, Sarah. A question's just popped through from Michael Gandy. How do we calculate usual hours for an employee who left in September but was then re-employed in October? Are you able to cover that one in the answer that you've just given there? Because obviously it relates, doesn't it?
Yeah, so you sort of use the same periods actually to do usual hours. And you, for someone who is on fixed hours, you take the same periods and you look at what their fixed hours are. So again, you would look at either the number of hours in the pay period before March or the number of hours in the pay period before October, depending on whether you're using the extended scheme after the 1st of November and whether they for the first time or whether they've been furloughed previously. For those on variable pay, again, it's the same periods, but you're looking at hours instead of pay. For those that have been furloughed before and were employed by you before the 19th of March, you're going to look at what their average number of hours were, either in the last pay period before the 19th of March, or for those on variable pay, the average number of hours they worked in the previous year's corresponding period. So the same example, April 2019 for April 2020, the number of hours, or the average number of hours they worked over the previous tax year. And for variable pay, if you're using the scheme for the first time after the 1st of November, again, you look at their hours for fixed term employees in the pay period prior to the 30th of October, or you take an average number of hours between the 6th of April 2020 and the day before they start a period of furlough, or the day they started with you and the day they start period of furlough. So it's the same period, and there's no specific changes to that if it's somebody that you've dismissed and re-employed under the terms of the scheme.
Hope that answers your question, Michael. Clear as mud. It is a bit hopeless, like Sarah said, because the guidance is it's lacking in detail. But if anybody does have any specific questions about calculating a certain employee's wages, then let us know, and we'll be able to sort of guide you through it and give you a sort of specific answer and some sort of definitive advice in relation to any individual sort of issue that you've got. Okay, moving to the second question that was submitted in advance of this session. If I have a member of staff who is employed and I want to make them self-employed, how can I do this in the current climate? Okay, so I think the sort of starting point on this one is that the fact that sort of furlough exists, the fact that we're in the middle of a pandemic, doesn't actually alter the procedure that you would need to follow in order to move someone from an employed status to a self-employed status. And the sort of primary point on that is that you don't have any automatic right to move an employee from fully employed to self-employed. If you want to do it sort of in the absence of a formal process, then what you need to do essentially is get the employee's agreement to the change in status. But what that agreement will have to entail is either a mutual termination of the employment relationship or a resignation on the part of the employee to end again that employment relationship. Once the relationship's ended, however it's agreed to do it, you can then re-engage the individual under a self-employed agreement, which will run completely separately to any pre-existing employment contract. But like I say, you don't have an automatic right to sort of just say to somebody, right, okay, you were employed, but now I want you to be self-employed. Here's a new contract, I need you to sign it. If you can't get an employee's agreement or they're reluctant to resign, then the only other way that you could seek to do this would be within the parameters of a redundancy situation, a redundancy process. But that would necessitate a genuine business case that demonstrates that there is a genuine reduction or cessation in the work that the individual actually does under their employment contract. If you can identify that, and this is where COVID may become relevant, i.e. a reduction in work because of the impacts of the pandemic, maybe you've had to close your business due to lockdowns, and if you can demonstrate that business case, then that can give you the sort of the right then to have a conversation with the employee, tell them that their role is at risk of redundancy because of the business case that you've identified, and then consult with them to try and find an alternative to redundancy. Now, the slight issue here is that a self-employed contract is not going to be classed as a suitable alternative to redundancy. So in all likelihood, you'll still have to terminate their employment. You'll still have to pay them redundancy pay, but then you might be able to get them onto a self-employed contract, a brand new arrangement going forward. But there isn't any sort of, again, automatic way for you to avoid the contractual obligations which come with the normal termination of contract. So I suppose the sort of very short answer to the question is that it's not overly simple to move someone to employed to self-employed, but have a conversation with the employee, scope them out, see how they feel about it, and if all else fails, sort of default to process, but knowing that you're going to have to make some kind of payment to them in terms of notice and redundancy pay if they've been there for more than 2 years.
Thanks, Charlotte. I think there's an important question come through actually pre-webinar today, which is something that's only just recently been clarified. And the question we had is, we have staff on notice of redundancy, and this is their final month's redundancy pay. Can furlough pay be used? Now, I'm assuming really here we're talking about somebody who is on furlough but working their notice. I say working, they're on furlough during their notice period. Now, up until, and this is, as I say, just been clarified, from the 1st of December, you can no longer claim under the job retention scheme for employees who are on notice. So you would be funding the full amount of any notice pay that they received during that time. But for employees who are working their notice on furlough during their notice prior to the 1st of December, you can continue to claim under the scheme for the wages they're paid during that time. Now, previously, it's been very clear that that relates to both statutory minimum periods of notice and any contractual notice that might be over that. It's a little bit unclear at the moment for current periods, basically from now up until the 1st of December, whether you can only claim for statutory notice periods or whether you can claim for contractual notice periods as well. That hasn't been made completely clear. So hopefully we'll be able to confirm that. But I think at the moment, it is the case that until the 1st of December, you can continue to claim for those that are on notice, but after the 1st of December, you won't be able to. You'll need to fund the full amount for that.
I think this question to me can be interpreted in two ways. The answer that Sarah has given is absolutely spot on, but I'm not sure what the intention was behind this question. If the question was actually, can you use furlough for redundancy pay and not just notice pay, then the answer is actually different. The answer is no, you can't use furlough pay to contribute towards redundancy pay. You are liable for the full amount of redundancy pay as an employer. It's only the noticed pay and any holiday pay that you might seek to wrap into the notice period that you can claim under the CJRS for at the moment. So just be aware that there is a difference here. And last week, I think it was, all my time just blurs together now. It's like I'm living in some kind of weird time space continuum with everything furlough. So it could have been 2 weeks ago. The government actually introduced a new piece of legislation to specifically say that redundancy pay must be based on an employee's full wage. It can't be based on an employee's furlough wage. I think it was it BA, Sarah, who tried to pay their employees redundancy pay based on furlough pay.
Yeah, I think it was, and there've been a few situations where people have tried to do that because of the basic rules on how you calculate redundancy pay. So it definitely required some clarification.
Yeah. There was a couple of high profile cases, but in any event, it's being clarified now with the introduction of that legislation. So yeah, hope that answers your question in full in any event, whichever way.
And I was just going to add to that, because Linda Woolley's just asked for some clarification in relation to notice and furlough, because it's a question of employees who before December have been working or have been on furlough during their notice and they've been claimed for. Will there be an expectation to repay the furlough on those notice periods? No, there won't. Obviously, after the 1st of December, you won't be able to continue to claim that contribution towards notice if the notice periods are going to run that long. And if you've already made a claim for anything after the 1st of December, you will have to repay or adjust that. But up until the 1st of December, you won't have to repay anything in respect of those claim periods. Hope that helps.
Right, okay, so thank you for all your questions that are coming through. Very exciting. We'll get around to as many as we can, and please pop more through if anything comes to mind. Final question that was submitted in advance of the session this morning. We had a receptionist start on the 13th of October. The monthly payroll was run on the 2nd of November. As she was on the payroll before the end of October, will she be eligible for furlough pay? Now, the question here depends on when the RTI submission to the Inland Revenue was made, or HMRC for the purposes of PAYE. If this was made before the 30th of October, then yes, your individual will be entitled to furlough pay. If, however, the RTI wasn't submitted until after this date, so the 2nd of November, if it falls on the day of your payroll, then unfortunately she won't be entitled to furlough pay. There has to be a cut-off at some point, and that's the cut-off that the Treasury has decided to implement in respect of the extended furlough scheme. So yeah, might need to run that past your accountant or your payroll provider to get some clarity from them as to when they ran that RTI. So yeah, again, hopefully that answers your question. Right, so on to the live ones then.
Yeah. So the first one that came through on the live chat was from Angela Williamson. The question is, are employees entitled to earn overtime on the days they work if they're on flexible furlough? Yes, they are, because it's sort of specific days that the furlough claims relate to. So they will be able to earn overtime on those days. That's fine.
Yeah, I think the basic premise there is that when somebody is on flexible furlough, any working days are worked in accordance with their normal existing T's and C's. The fact that they might be on furlough for other days, the fact that might have been on full furlough, the fact that there's an intention to put them on full furlough doesn't mean that you are entitled to circumvent any of your existing obligations or for you to disapply any obligations that exist with regards to pay or anything else. So it's kind of just business as usual. If you do want to alter any of your employees' existing terms because of the furlough arrangement or because of other business needs, then it's possible to do it, but you need your employees' agreement just in the normal sense to do that. Now, when you place an employee on furlough or flexible furlough, obviously you need their agreement to do it. And if you have been using the templates that we've issued, you'll have gotten fairly familiar, I would have thought, over the last few months with our sort of lengthy furlough agreement. Now, what that agreement does is two things. It ticks the box as far as HMRC are concerned in respect of having a robust agreement in place, which is obviously one of the requirements of the CJRS. But it also ticks the employment law box in terms of getting a valid variation to contracts in place. Furlough in itself is a variation to contract. That's why you need your employee's agreement to it. But all of the other kind of changes, the contractual changes that are incidental to being placed on furlough are also separate variations in themselves. So if actually what you're thinking here is we want to, I don't know, disapply the overtime provisions during the period of furlough, like I say, you can do it, but you need the employee's agreement to do it. But that type of agreement where you're already listing changes would be the perfect place to do it. So it's not that you can't avoid existing obligations, it's just that you need your employee's agreement to be able to do it. So perhaps a bit of food for thought there in terms of changes that you might want to make during the extended furlough scheme period. Okie doke, so on to a question about sickness, everybody's favourite topic. We have an employee who is on flexible furlough, working 3 days a week, but has been diagnosed as COVID positive and is consequently on 2 weeks sick leave. Should they be paid 3 days per week SSP and 2 days furlough, or 5 days SSP per week? Honestly, this is the $64 million question. And there isn't a clear answer on this still. It's been something where there has been a question mark hanging really since the inception of the furlough scheme, because on one hand, the current guidance says that individuals who are unable to work because of COVID-related illness can be furloughed. They can receive full furlough pay. On the other hand, it says that the furlough scheme is not intended for periods of short-term absence, and anybody who is absent from work in the short term should therefore be paid SSP. And the guidance goes on to extol the virtues of the SSP rebate scheme, and lets us all know how generous the Treasury are being in terms of allowing employees to claim SSP back from day one as opposed to day 3. So it's not clear cut. The answer, Gareth, is you have a choice. You can either pay 5 days SSP, you can either fully furlough, or you could pay 3 days SSP and 2 days furlough as per the flexible furlough arrangement. My very best advice on this, though, would be to contact HMRC and get an answer from them direct, because if anybody has any issues with this, it's going to be HMRC. So if you have something on record from them saying one way or the other, this is the approach that you should take, then not only are you going to have a defence should they come sniffing around later down the line, but you'll also be able to explain your position in very clear terms to your employee as well in the event that they have any issues. But yeah, it's not clear cut, unfortunately. I don't know if you've got any sort of other pearls of wisdom to add on that one, Sarah.
No, I think I would agree with that. The guidance is a little bit unclear. It certainly says that if an employee is already on furlough and becomes sick, you kind of have a choice whether you keep them on furlough or switch to SSP. You can't do both. It does say you can claim SSP rebate and furlough for the same employee, but not for the same period. So you kind of have to choose. Are they going to be furloughed and getting paid under the grant, or are you going to switch them onto SSP as sick and pay them SSP? And you choose, really. And that might a little bit depend on how long they're sick for. I think Gareth's question said 2 weeks. So you have a choice, because if you say have someone start sick, a period of sick, and that runs over a period when they would otherwise have been on furlough, you can then choose whether you keep them on that furlough or switch them to SSP.
I think as well, there's a sort of a wider kind of issue really, and that's consistency across your workforce. You know, furlough, COVID aside, you should always apply a consistent approach to payment during sickness, absence, to prevent grievances, at worst disability discrimination allegations. So whichever approach you decide to take with this individual or a particular individual, you need really to be thinking about replicating that approach across the board. Yeah, so just to muddy the water a little bit more, it might be, you know, appropriate, given that there are so many different ways in which SSP can now be paid, given that there is the choice about furlough pay, for you to put together a bit of a management guidance document that you look at internally, and which has some steps for determining what you will pay to people in what circumstances. That type of document, it will, you know, hopefully bring some clarity to the management team, but also in the event that an employee does seek to question the decision that you've made with them, and, you know, raise all kinds of allegations about the way that you've treated them, it will show that actually you weren't being sort of arbitrary or discriminatory. You had a clear, considered operational document that you worked to in making the decision. It's not something you have to do, but it's something that you might want to have a think about, as if we're not all busy enough as it is getting through this pandemic to be drafting up non-essential management guidance.
We all need extra work.
Yes. Oh, is it your turn, Sarah? Is
it's
it
my turn? Yeah. You're in a flow now, Charlotte.
Yeah.
You're good. So Kevin Winterburns asked a question, which is actually a really important question, I think. It says, have I read correctly that from November, those businesses who are claiming the job retention scheme grant will go on a public register? Yes. So they have said that for any claims from the 1st of November onwards, they are actually going to publish the names of businesses that do claim under the grant scheme, and also an indicative amount of the value of that claim. And that is going to be publicly available. We have no idea the purpose of that. They've not really been entirely clear on why it would be necessary to print that information. So it's going to be interesting, I think, to see where that goes, whether it's really with a view to sort of further audit trails, keeping an eye on businesses. Maybe, you know, it's a bit of a deterrent for some businesses that are possibly making claims when they don't particularly need to, or shouldn't be using the scheme. But yes, it is now going to be publicly available.
Yeah, it's quite scary, that, really. I mean, at worst, this could be a list of businesses who are going to be eligible for additional taxes next year because they've used the furlough scheme. At best, like Sarah says, it's just a bit of a deterrent. But yeah, we literally don't know what the purpose of that register is. Although I'm sure I've read something to say that further details about that are going to be published at the end of this month. So obviously, when anything is sent through, we'll update you. But yeah, a little bit alarming, really, I think, actually, that latest development. Okie doke, next question. Is it still the case that staff on furlough accrue annual leave? Yes, it is. There has been absolutely no changes to the position on accrual of annual leave during furlough. I'm still not 100% sure that I necessarily agree with it. Not that that's relevant at all, but I'm just not sure, particularly if employees have been on an extended period of furlough. I'm not sure whether it's right that they should get a full year's allocation of statutory and contractual holiday on top of that as well. But I don't make the rules. But yeah, it does still accrue. There can be a distinction between statutory and contractual pay, and you know, please do contact us if you've got any questions about that and the interplay between the two. But one thing that is quite important to bear in mind is if you are in a situation, or you are going to be in a situation where you have a number of employees who've been on long-term furlough and who have a load of annual leave left, the working time regulations have been amended to allow a rollover of the statutory holiday for up to the next 2 years, which can hopefully ease the cash flow issue that some businesses might have. I accept that it doesn't solve the problem, it does just kick the can down the road to some extent, and you are, as an employer, still obliged to do all that you can, all that is reasonable to get your employees to use up their leave this year. And we know that leave can be taken during furlough as well, as long as the pay is topped up, so bear that in mind too. But worst case, you can look at rolling holiday over. If you do that, have a word with the employee about it, make sure they're on board. But you don't have to just do that with furloughed employees. It applies to all staff as well, because the converse is true as well. You've got employees who are on furlough accruing loads of leave, not being able to sort of take it because they're on furlough, but then you've got staff in work, perhaps the skeleton staff, who can't take leave either because they're so busy, because they're picking up the slack from the people who are on furlough. You can still roll over the people who aren't on furlough's holiday into the next 2 years if you need to. There is a new section on the gov.uk website all about holiday. It just sort of brings everything that we previously knew about annual leave together. So it's not groundbreaking in any sense, but it's certainly a good place to start to get a good overview of the holiday provisions.
I think also looking at that new sort of section, it does seem to indicate that there's an expectation that if people are on long-term furlough, they won't need to roll holiday over, and there will be a case of people taking holiday whilst on furlough, because there is a part that says it's unlikely for those that are on long-term furlough that you'll need to do this. I think it sort of envisages more the employees that can't take it because they're so busy and not furlough will carry leave over rather than anything else. But I mean, that's not absolutely required. You can still utilize it, but it is worth just bearing that in mind. So yeah, just have a chat with us, obviously, if you've got a situation like that, and we can talk you through what you need to do.
Yeah, and just as a final point on that, don't forget that if you dismiss somebody on grounds of redundancy or otherwise, and they're working a notice period, they're staying in your employment during a notice period, you can place them on holiday during that notice period. You have to give them notice of that in the same way, so you have to give them double the amount of notice. I can never explain this right. You have to give them notice that's twice as long in length as the holiday that you want them to take. So if you want them to take 3 days holiday during the notice period, you have to give them 6 days notice. That applies whenever you want to enforce an employee's holiday included in the notice period. But that is something, like I say, useful to bear in mind, because it can help reduce the total amount payable to the employee on termination by way of payment in lieu of untaken holiday. So if your concern is cash, then that can be a useful way of reducing your liability.
So the next question we've got is from Karen Petrillo. It says, I work for a public body. We have a few members of staff who have to self-isolate, and they work for the catering department, who generate cash that pays the costs in that department. So they're not directly funded by government money. Can I put them on furlough until the 2nd of December? I think there's sort of 2 or 3 points that are a bit different in that question, and I'll try and remember to cover them all. The first one, I think, is the public body point. In general, if staff costs are publicly funded, then you should use that money to pay the staff and not use the job retention scheme. So basically, for staff that are paid through public funds, you can't use the job retention scheme for those employees. However, if your business is not fully funded by public money, so you have some employees who are paid by other means, and looking at this, they're not, your catering department staff are not funded by public money, they're paid based on the money that comes into the catering department, then potentially, yes, you could furlough those employees because they're not publicly funded. So yes, you could put them on furlough until the 2nd of December, assuming that you obviously don't need them to be working, or you need to put them on a flexible furlough arrangement so that they're working part-time effectively. But the other kind of couple of points to make, you mentioned that they need to self-isolate. So as we sort of mentioned before, the furlough scheme isn't really designed to cover short-term absences. So if it's the case that they're still simply self-isolating because of symptoms, or because it's a couple of weeks for the household, then that's something would normally be covered by SSP, and it would be sort of sick leave on that basis. But if they're sort of self-isolating because of sort of serious medical conditions, so it's a longer term isolation period, then potentially, yes, they could be furloughed, again, as long as their job is not publicly funded. And what the government have said is that if employees are clinically extremely vulnerable, and there is a specific list of conditions classed as extremely vulnerable, then employees can be put on the furlough scheme. And also for those that are at the most serious risk, or at the highest risk of serious symptoms, can also be put on furlough if they need to isolate and shield. I think a similar system is running in terms of people being told whether or not they should be shielding at this point. And if they are told that, then they could well be eligible for furlough. But equally, they could also be covered by SSP as well. There's an element of choice here. You don't have to utilise the furlough scheme for those staff. You could simply class them as sick and pay them SSP. But equally, you could put them on furlough as well. I think that's all the points that I wanted to cover on that. Can you think of any others off that question, Charlotte?
suppose it's more of a discussion point, really, and I'm sort of thinking off the top of my head, really, but there's 2 points, I guess. You're right when you say that there's a choice, probably, in terms of SSP and furlough. However, where an employee, and I'm not sure if this is totally relevant here, Karen, hopefully it is, but where an employee is contractually entitled to full pay during sickness absence or COVID-related absence, because some public sector contracts are obviously negotiated through unions, and there is provision in some of them to say that where an employee is off with an infectious disease, then they get full pay anyway. Obviously, furlough pay is only at 80%. So I wonder if actually there isn't a choice, because if you put somebody on furlough, would you then potentially be subjecting them to a detriment in terms of pay? Because if they were on sick pay, they'd actually be due 100%. And because you have a choice, you should really be picking the option that best favours the employee as opposed to the employer. So that, like I say, more a discussion point really, and something perhaps to flesh out in the event that you need further advice on this, or in the event that this crops up with anybody else, an employee who is contracted to 100% sick pay, but you have a choice to put them on 80% furlough. I think I addressed this sort of second point there, which was the terms of any negotiated contracts and what that says about COVID-related absence or isolation or anything like that, because there might be something anyway, like I say, that triggers 100% payment obligation, even if you have a contractual choice as to whether to pay SSP or occupational sick pay.
I think the other point to make as well, though, is if you are putting someone on furlough, then you are varying the terms of their contract. So if you were to vary the terms of their contract to say that during any period of sickness absence on furlough, you can limit the sick pay to of furlough pay. But you would need the employee's agreement for that, because it is a variation of terms. So whether you'd get that for an employee told to shield, there might be a little bit daft to agree to that. But it is another point to make. And I think, as Charlotte says, it's something that we probably would need to talk through in a bit more detail if you wanted to implement something like that, to really get the details of who we're dealing with and the contractual details. But there's a few different bits on that one.
Okie doke. So I'm conscious of everybody's time. I'm not one for sticking to time limits, but I've been told off by the powers that be, and I'm under instruction to stick to webinar timescales as best I can. So obviously this was in the calendar for 45 minutes. We've got 2 minutes left and 1 question. So perfect, I think. Julia has asked about an employee who is on flexible furlough. We have an employee who is on flexible furlough working 25 hours over 3 days. Can we change the agreement to continue to work 25 hours but over 5 days and still claim furlough for the unworked hours? Yes, you can do that. You will need to change or get agreement from your employee as to the flexible furlough arrangement that's currently in place. Unless you have entered into an agreement with them which allows you to sort of vary the hours and days worked at whim, then you'll need a specific document in place to reflect the change from 3 days to 5 days. But provided you can get that, there's nothing to stop you from having an employee work over 5 days, albeit shorter hours, and then claim furlough for the unworked hours. The flexible furlough scheme is exactly that. It's flexible. So it doesn't require employees to have full days off. It doesn't require employees to have full weeks off. It's just about being furloughed, not having sufficient work to be able to work all hours. So that will be fine. In terms of actually making the claim to HMRC for the furlough pay, I'm not sure whether there'll be any impact there, but there is obviously that 7-day claim period window, which you might need to bear in mind if you are looking at shifting things around. But otherwise, perfectly doable in practice. So yeah, 10:44, 1 minute left. Thank you for joining us. I quite enjoyed that in the end. I was quite nervous at the start. But yeah, I think by Sarah's smile, that means she enjoyed it as well.
Yeah, it slightly tested my brain at 10 a.m. But no, we're all good. It's always good to have a bit of a challenge.
But yeah, hopefully you enjoyed that. Hopefully it was useful. If you want to discuss anything with us by way of follow-up, then you know where we are. And yeah, we'll hand over to our colleague Louise, who just has a few bits and pieces to tell you about. But otherwise, thanks very much.
Thank you, Charlotte and Sarah, and thank you for everybody for attending. So I know we've got a mix of clients and non-clients online. So for any clients that are online, have got any follow-up questions, get in touch with your advisor, drop them an email or give them a call, and they'll be happy to pick them up for you. For any non-clients that we've got, that'd be interested in a further conversation in how we can help, we'd be happy to have that conversation. So we can help with everything from documentation, initial setup, through to advice. I'm sure you've seen an example of that with the team today, and ongoing support and training. So if you are interested in further conversation, a bit of a health check, I suppose, just drop me an email on louise@howards-uk.com or give the team a call on 01274 864 999 and we can have a chat about your requirements. Now, we will follow the session up with a Q&A blog article, and we'll also email out the recording as well, so do keep an eye on your emails. And then moving forward, we've got a few more events coming up, so if you are interested, if you email myself or Justine at howards-uk.com, Charlotte will be hosting a session on the 30th of November on everything that you need to know about the new immigration laws, and again held at 10 a.m. and 2:30. We've got an Essential Skills for Managers course, which is ILM accredited. Now that starts on the 11th of January. It's going to run Monday to Friday for an hour a day, 9 till 10. It's £250 plus VAT, and there's a discount for multiple bookings. So if you are interested, do let us know. And finally, moving further into next year, we've got a session on keeping home workers engaged and motivated from Kath and Katie in our HR projects team. So some really interesting sessions coming up, and I know you all do enjoy them, so do let us know if you want to attend, or go on the website and you can register your interest. Very finally, we'll be a little bit cheeky, but I know we do get a lot of clients passing referrals our way. If you know somebody who's interested and you're happy with our support, if you go to our website on the referrals section, you can pass either a friend or a company that you know our way, and we'll get in touch, and if they come on board, you do get a voucher of £150 of your choice. So that's me done. Thank you all for joining. Enjoy the rest of your day, and we'll hopefully see you again soon.